Good morning, everyone. Very fine good morning to one and all. At the outset, I should thank the MBA for inviting me for this session. And we are really making good use of this COVID lockdown. I am also getting enriched listening to various lectures. And when I am asked to give a lecture, I have to do so much of homework, and that makes me to read a lot of things. Today's topic is FALSUS in FALSUS in Omnibus. It's really a very interesting topic about which we can speak for days on end. Now, what is the simple meaning of this expression, FALSUS in FALSUS in Omnibus? The simple meaning is false in one thing is false in everything. Now, every culture all over the world have been grappling with the problems of persons speaking lie in a tribunal or in a court, and how those cultures have been dealing with this is something about which we should first know. For example, I tell you, if you take the 10 commandments of which Moses got, you'll have one commandment: thou shalt not bear false evidence against thy neighbor. So this means that even during Moses' times, neighbors were speaking lies against the other in a court, whether informal court or a formal court or whatever it is. This is one side. Here in the eastern side, we have Tirukural, தன்னெஞ்செறிவது புயர்க பொய்தப்பின் தன்னெஞ்சே தன்னை சுடும், one full அதிகாரம் where Valluvar speaks about the necessity to speak truth. Then of course we have the Upanishads, the Mundaka Upanishad, which says Satyam eva jayate nanurutam satyena panta vitato devayanaha. This Satyam eva jayate has been lifted from Mundaka Upanishad, and that has been included in the Government of India's emblem. Down south, we have Vaaymaye Vellum. Our Tamil Nadu government emblem is Vaaymaye Vellum. So all over, all cultures have been insisting that people should speak the truth. And only then society can really have some meaning and institutions can grow. Now, coming to this falsus and omnibus principle, history shows that it evolved in England sometime during the period of the Stuart Kings. You are aware that the Stuart Kings had the Star Chamber with them and a process of various laws. And during those periods, the concept that if a person speaks a lie on one fact, then the judge will address the jury that even if he speaks truth on other facts, don't take his testimony, reject his testimony. Falsus in falsus in omnibus. False in one thing is complete false in the whole testimony, and his whole testimony used to get rejected. This was there from the Stuart King's times till about 1809, when Lord Ellenborough, in one of the judgments, says that this principle cannot be taken to too much extent and it has to be given up. However, this principle falls in a court, falls in as I told you earlier, that all of us, all these cultures have been grappling with this concept of lie. Now, lie is one thing. I will divide the expression false broadly into two categories. One is a lie and another is untruth. Lie and untruth are little different. I'll explain to you in the course of my talk. First is lie is simple. Something which you know not to be the truth, you tell that is a simple lie. It's a lie. Now, lie in the judicial system has been very frowned upon, has been totally frowned upon. For example, I will give you three. I'll give you two cases, two live cases, which you will really, which you know, but and I'll recollect those facts. You are aware that in England, the common law developed because of the contribution by judges. It was a judge-made law. Judges, great judges like Mansfield, Coke, Hasbury, all these people had contributed to the growth of the English common law. Now, English rules of evidence and English criminal law was basically evolved in order to protect the common citizens against state tyranny. See, the kings were tyrants, the judges stood against the kings, and they evolved the common law in England by which the common man was to be protected. So the common law principles were evolved by judges over a period of time for protecting the common man against the tyranny of the kings. This is how it grew there. The common law grew there in England, contributed by various judges, about whom I referred to. Now, this falsus and falsus and omnibus principle that you reject the testimony of a witness if he is found to be false in one thing completely, was there till about 1809, when, as I told you, Lord Ellenborough said that this is not a principle to be followed. It cannot be, because for various reasons. And though the English common law gave up that principle, nevertheless, they were very, very particular that the lie in a court of law was taken very seriously by them. This is for the reason that for the English people, the court is the greatest institution. It's an institution which the English believe had always protected them against state tyranny, as I told you earlier. So they would always want to preserve the sanctity of the court, because lest they feel that if the court's sanctity is lost, the liberty is lost. This is their feeling. Now, when the English principles went into America, when post-American independence, they also adopted these principles. And I understand that America, this falsus and falsus and omnibus still continues to apply, subject to correction, of course, continues to apply, though, as I told you earlier, 1809 itself, England had given it up. So both in America and in England, the principle is that in a court of law, you just cannot lie. You just cannot lie. Because they feel that if you lie in a court of law, justice will be the first casualty. I'll tell you one example. I'll take one famous example which you all know from England. I'm sure you would have read Jeffrey Archer. Jeffrey Archer, very name Jeffrey Archer, will remind you of Cain and Abel and all the long line of books which are. It's a master storyteller. It's a master storyteller. Even today, you take a Jeffrey Archer book, you can't just keep it down. That is the. Now, what was the sin Jeffrey Archer committed? Jeffrey Archer was a member of the Conservative Party. He was elected to the House of Lords. He was sent to the House of Lords, and he was a Lord. There was a press by name Daily Star. You know what had happened was Daily Star published a news item in which they said that Jeffrey Archer was found in the company of a lady by name Monica Coghan on a particular day. He was an MP. He was an MP, Conservative MP, and that lady's character was little doubtful. So he was found in the company of the lady on a particular night. That is what the Daily Star published a news item. Jeffrey Archer, what he did was, he filed a libel suit against Daily Star, claiming damages from them. In that libel suit, what he did was, he made his friend Ted Francis to get into the witness box and give evidence that on that particular night, Jeffrey Archer was not in Monica's house, but he was in his house. And Ted Francis got into the witness box and gave evidence. The court believed that it was in 1986, mind you, 1986, 86 or 87. He gave evidence, and the court believed his evidence, and the suit was decreed in favor of Jeffrey Archer. Huge compensation was directed to be paid by Daily Star. The matter ended. 10 years later, 1996, what happens is Jeffrey Archer is proposed for the London mayorship. He would have won in that election had he contested, or it was there. So Ted Francis suddenly felt that such a person who made me to speak a lie should not become the mayor of London. And this made him to spill the beans, saying that 10 years back, the suit was filed by Jeffrey Archer. In that suit, I spoke a lie. I'm sorry, I ought not to have spoken a lie. My conscience is pricking me, he said. It's very serious note of it was taken, though Jeffrey was a very powerful person. All I would have read his books, and he was a very popular person. Nothing doing. You spoke a lie in the court of law. A prosecution was launched against Jeffrey Archer, and Ted Francis gave evidence, incriminating himself, incriminating Jeffrey Archer, and the court sentenced Jeffrey Archer to 4 years imprisonment. This is how the English courts deal with a lie, perjury, and sitting in the jail. Of course, Jeffrey Archer wrote a beautiful book, Prison Diary, something, and that's also worth reading. You know, as a master storyteller, this is one thing. This is America. This is England. Now come to America. American system, as I told you, they also adopt the same system, and they also frown upon perjury. They do not want witnesses to speak any lie whatsoever. This is a case of the President Bill Clinton. What was the case against Bill Clinton? Bill Clinton was a governor of Arkansas. While he was the governor of Arkansas, what had happened was a lady by name Paula Jones complained that she was sexually harassed by Clinton, and she filed a suit against him in the Arkansas court. When he was a governor, it was filed. Then 1994, the suit was filed. And by then, Democrats give the ticket to Clinton, and Clinton gets elected. Clinton takes a plea that I have immunity, I do not appear before the court. Then Supreme Court of US rejects that petition, that claim and all, and ultimately the Arkansas court starts taking, the trial goes on when this man is the president of US. Now, what had happened was Jones' lawyers wanted to get some evidence to show that Clinton has a behavior of sexually harassing other women. Such evidence in our judicial system is relevant under Section 14 of the Evidence Act. So they were looking out for evidence. And at that time, what had happened was Monica Lewinsky was joined the secretariat as an intern. She seems to have had an affair with Clinton, and which she was speaking to her friend over phone. Her friend invited her for a conversation, and she recorded that conversation. And this conversation was given to the lawyers of Paula Jones in the Arkansas case. And Monica Lewinsky was added as a witness in that case. Now, this issue became very big. Clinton, in the trial of Paula Jones' case, Clinton got in the witness box and stated that he had no affair with Monica Lewinsky. He completely denied that. But what had happened was an investigation, private investigation was ordered by the law department, and one star, a private investigator, he went about investigating the whole thing, and he said that yes, there is enough material to show that this man has had an affair with her. And he was asked to appear before a grand jury of 24 jurors. Now the problem, the impeachment motion against Clinton was not the affair with Monica Lewinsky. No. The impeachment motion against Clinton was for having spoken a lie that he did not have an affair with Monica Lewinsky. Monica Lewinsky, at one point of time, she spilled the beans. She said, yes, this is the cloth which I had at the time of thing. And evidence became so strong that Clinton was branded a liar. The House of Representatives impeached Clinton. But since the Senate had a lot of Democrats, Clinton managed to avoid the impeachment proceedings. Like now, how it happened to Trump, the Republicans who had the majority in the Senate, managed to save Trump. In those days, Democrats had the majority here and they saved Clinton. So he managed impeachment. But you know what that judge in Paula Jones' case did? She fixed him for perjury. Fine. She imposed a fine of $90,000 on Clinton, and the Arkansas bar debarred Clinton from practicing in Arkansas for 5 years. Notwithstanding that, US Supreme Court also said, Mr. Clinton, you cannot practice. So this is how, for the lie that I did not have an affair. See the irony for Archer is also Monica Coughlin. For Clinton also Monica Lewinsky. I don't know whether it is a sheer coincidence or I really don't know. It's sheer coincidence. Now, as I was telling you, these two cases of interest were to show that speaking a lie is not easily taken up in all these two jurisdictions, these two democracies, for the simple reasons, as I told you earlier, for them, court is very dear to them, and they do not want any lie. Now, shift the scene to India. Now, shifting the scene to India, I will come to the reasons. Before that, I would just like to quote one judgment of the Judicial Committee way back in 1889. Swarup Chandra Sarkar, Madhusudan Sandyal was a Swarup Chandra Sarkar. 4 more Indian appeals, 441. 4 more Indian appeals, 441. This is what the Judicial Committee says. In India, there is the free admixture of falsity and truth in the evidence of witnesses. It is quite true that such is the lamentable disregard of truth prevailing amongst native inhabitants of Hindustan that all oral evidence is necessarily received with great suspicion. This was, what used to happen is, our people used to get into the witness box in the courts, and each one would speak whatever he thought was there. For example, if a suit for a share in a property, one brother will get into the witness box and say that his deceased father came in the dream and told him that this share belongs to you. Then the other brother will say, no, mother came in my dream and said that this property, share belongs to you. This sort of evidence, left, right, and center, they used to adduce in the courts, that the judges there became mad. They said, what is this? There is no regard for truth at all. Somewhere we must have to see that these people are made to speak about relevant facts and nothing more. Because you allow them to speak, then each one speaks his own mind, whatever it is. Then the need to have a codified law of evidence was felt in order to control this sort of unlimited talking. Because basically we are loquacious in nature, we are very sociable, we talk, discuss, and that the court also was used as a medium to talk. Now, Stephens gets into the business and he drafts the Indian Evidence Act. Now, if you take Section 5 of the Indian Evidence Act, it would say that whatever evidence is permitted, whatever relevant evidence is permitted within as provided under the Act and nothing beyond that. Section 5 is very clear. You cannot adduce evidence beyond what we have stated as relevant herein after Section 5. So relevant, you must have to speak relevant, and he has clearly stated what is relevant. This is relevant, dying declaration is relevant, that is relevant, all the things are relevant, so that you don't talk irrelevant things in the court of law. Right. Did this in any way stop our people from getting into the witness box and lying? No, that also never stopped. If you take the first book that was written by C.D. Field on commentaries to Indian Evidence Act, he would refer to a case where a plaintiff filed a suit on a forged promissory note. The defendant filed a written statement based on a forged acquittance. Simple. The defendant did not waste his time saying that no, I did not execute the promissory note. because he knew that it's a forced promissory. His signature has been forged. What he simply did was he went to the same forger from whom the plaintiff had his signature forged. He prepared an acquittance and he filed written statement saying, yes, this I took the on Diwali day or whatever it is. I went to his house, returned the money. This is the acquittance. This is how our people were dealing with even post-Indian Evidence Act. I would like to just, I do not know how many of you all would know about Mayuram Munsif Vedanayagam Pillai. There was a great judge, Mayuram Munsif Vedanayagam Pillai, during 1885 times, who must have come to the High Court as an High Court judge. But misfortune fell on him that he did not continue to be the post. And he has written so many songs, and some of his songs are being sung now by popular singers. He's a musician, a great Tamil. And you know something, he was a person who wrote the first Tamil novel, Pratapa Mudaliyar Charitram. Pratapa Mudaliyar Charitram is the first novel written in Tamil by Munsif Vedanayagam Pillai. Now, Vedanayagam Pillai, it is one of his poems, because as a Munsif, he has heard so many people giving evidence in his court. In his poems, he says like this: Anda Purattan Anda Vadi, Agilanda Purattan Appa Avan Pradivadi. I'll read again. Anda Purattan Anda Vadi, Agilanda Purattan Appa Avan Pradivadi, Sanda Prasandan Nyayavadi, Nalum Sastra Pulagan Kachikaran Ennum Kyadi. Sanda Prasandan Nyayavadi, Nalum Sastra Pulagan Kachikaran Ennum Kyadi. This was the state of affairs in 1887 when Samuel Vedanayagam Pillai wrote this poem. And you know, it didn't abate at all. It never abated. Why? I'll tell you. In 1981, I want you to read AR 1981 Supreme Court 613. It's a very interesting case of Prem Kumar Paniwala. Prem Kumar Paniwala was a person who used to sell water. You know, in those days, in Delhi, in hot summer, you'll find vendors with a push cart, with one pump-like thing with a lemon there. Those say 10 paisa you give, he will give one cup of water. Delhi will be very hot, May, June time. So, Paniwala Prem Kumar used to give water and 10 paisa, 20 paisa, whatever it is. He was a vendor. Now, what happened was, Prem Kumar Paniwala, you know, you have to have the blessings of the police if you are going to be a vendor. You know, street talker and street vendors have to have the patronage of the police, because police can anytime throw them out. So he was very friendly with the police. So what the police used to do is, they used to call Prem Kumar Paniwala for all the 27 recovery cases. Wherever there's a 27 recovery, the magazine will be prepared in the police station. From A1, knife was recovered, A2, hammer was recovered, A3, crowbar was recovered. All the thing, Panchanama will be written. Prem Kumar will sign that Panchanama. Fine, go on. And Prem Kumar would have signed in almost several police stations. He was a client of several police stations. Then he used to sign and go. Prem Kumar used to have a diary. In the diary, today, 4th additional session judge, SC number case. Then 6th additional court. Then 3rd additional court. This diary he will be having in his pocket, and he will do one thing. He will, according to the diary, he will go give evidence, and just before getting into the box, he will have a word with public prosecutor and this A1 knife, A2 hammer. All right, he'll sharp memory. He'll get into the witness, say from A1 knife was recovered, from A2 hammer was recovered, A3 crowbar was recovered. All that he will say perfectly. Then subject himself to cross-examination, get down, then go to the other court, give evidence and come. And judges also knew that Prem Kumar Paniwala, they will say, Prem Kumar Paniwala, okay, we'll wait, we'll pass over the case. He'll be giving evidence in some other court, he will come and give evidence here. And Prem Kumar Paniwala, he knew the defense lawyers well. He knew the prosecutors well, even the judges also knew him well. Everybody knew him well, and everybody, Prem Kumar Paniwala section 27 used to go on for days on end. It was going on. One fine day, what had happened was Prem Kumar's children and all became well settled in life. And they told Daddy, stop this. Stop selling this water and all. We are all grown up. You have served us all. We want to keep you at home. Give up this business or thing and stay at home. So he also wound up his way. He became old. The police fellow started calling him. You come. You need this seizure has to be done. Panchanama has to be done. Then his children said, Dad, stop this. Don't have to go. We are taking care. Then he said, no. My children are asking me not to come. I am not going to go. You know, these police people, they passed an order under the Delhi Police Act externing Prem Kumar Paniwala from entering into Delhi because they were aggrieved that he is not obliging them to be a witness. Then Prem Kumar Paniwala got damn annoyed. Naturally, he filed a writ petition in the Supreme Court saying, see, I have been obliging these fellows all along. I will tell you, SC number so and so, it is a false witness I gave. The recovery was not done. Everything these police fellows used to buy the market and they will keep it. SC number so and so, because he already had a diary with all the thing. He gave full details, filed an affidavit, and stated that my externment order is illegal for the simple reason that I have stopped obliging the police any further. And you know, it shocked the judicial court. It shocked everybody. Justice Krishna here. This Krishna, then the police knew that things are going beyond their thing. What they did was they quietly withdrew the externment order. But Krishna would have lamented at the judgment. At least it's time we stop this nonsense. This nonsense of this putting false evidence and all this. And there must be more truth in the system. Now, did ever truth come into a system thereafter? Truth never came into a system even thereafter, because even today this 27 recovery keeps running like this. Now I would just like to play one song. See, this is a song from Chinna Counter film, the title song. He says that, so the lyrics by Uday Kumar, he says that சாட்சிகளை செட்டப் பண்ணும் வேலை இங்கு இல்லை இல்லை, வக்கீலு பொய்ய சொல்ற வாதம் இங்கு வந்ததில்லை. Now, so the whole world looks at us that here false evidence is given and arguments by advocates are also there. Now, this is the, I'm asking you to compare the two cases I gave you of the West and what is happening in our country. Then you may ask me a question. Sir, are we congenital liars? Is it that Indians are congenital liars? My dear friends, I will not say so. I will just not say so because the standard of truth amongst us was no doubt about it that we were not liars. Truth was part of our culture. Mahatma Gandhi, people like Mahatma Gandhi who stood by truth till the thing, we have, and our scriptures, our life thing, even our Silappadigaram, when truth failed, the Pandyaman lost his thing, all that is there. Then how did such a thing happen? How did such a thing happen is the next question which we have to really answer. I would just tell you that earlier we had our own system of investigation and our own system of civil disputes. Investigation. The earliest record of one such this, what happened in 1642. See, 1642 is, I will just take you to this thing. You know that the East India Company came here. They came to this place, Fort St. George. It was not there. Fort St. George was not there. Pedanayak was the chieftain of Madras Patana. So he gave the East India Company that fort next to our High Court, that area, to have their establishment. When Andrew Cogan was the agent of East India Company, that time, 1642, a dead body was found floating in the Coombe River. So people gathered, everybody gathered, looking at the body. Then Cogan requested some of them to dive and pull the body to the shore. 4 fellows dived in the Coombe River, brought the body to the shore. The body was found to be that of a woman. There were no visible marks on her body to know that was a death. They thought that she must have drowned. The case was about to be closed as a case of simple drowning. One of the divers asked Cogan, I want money for having dived and brought the body here. When he asked for money, one fellow standing in that crowd just simply commented, after all, that lady has been having you all along. What is so great about asking money for having brought her body to the shore? That's all he asked. What he asked was, after all, the lady has been having you all along and maintaining you. You need money for having brought her body here. That's all. This arose a suspicion of everybody. Everybody looked aghast. So this fellow was having that lady. Then they started interrogating him again and again and again. And it appeared that that lady was alone. She was very rich. And he was keeping her, and they were having, and she used to give him a lot of money. One fine day, what had happened was the goose that lays the golden eggs principle. This man, what he did, he saw all her gold ornaments, everything, finished her off, threw her into the Coombe River, and took her ornaments and thing. So, how was this investigation? Our way of investigation, our thing is that Indian society is everyone knows everything about everyone, and in a public inquest, when it takes place, so much of truth will come. And when so much of truth comes in the presence of your own kinsmen, your own castemen, in the presence of your own environment, the question of speaking lies will be very less. Because everyone knows what you are speaking, and everyone knows that they will finally call the bluff. If this is how public inquest is, that is even today 174 CRPC inquest, why we are doing, because when a public inquest is done, so now the way the policeman is doing the inquest, don't go by what he's doing. He just writes the inquest report, or head constable writes the inquest report, or whatever it is, and something happens. God alone knows what really happens. But original idea of inquest was keep the body, ask the people around panchayatdars. Each panchayatdar will give an opinion, and a lot of things will come during opinion. A lot of enmity will come during this, like how this lady was having him. All that will come through opinion, and then they will get a lead to find out the truth. This is how 174 CRPC is so modeled. But how it is being done is leave it for a moment. Now, this is how it was until 1772. See, what had happened was when the British came here and started as East India Company, the Mughal Empire was declining. The power of the Mughal Empire was declining. And there was so much of lawlessness. There was so much of lawlessness in the area, because when a strong empire is there, Shivaji's period are also gone. Aurangzeb also gone. The last, the post Aurangzeb and the post Shivaji, the market declined. So much of law and order that Warren Hastings, what he thought was, he thought that we can bring in some semblance of order if justice is given, because they were all modeled from England. Justice and peace can be called as sisters, siblings. If you have justice, you will have to some extent peace, because justice will give you peace. This is there. We can't deny this fact. So he thought that why not we establish courts and outside the presidency towns. Already the presidency towns had the Supreme Courts of Calcutta, Supreme Court of Bombay, Supreme Court of Madras, for the presidency towns where settlement was there. Outside the settlement, so much of law and order problem. People were so much of their chaos in society. We'll have to put some courts. So what he does is he first establishes law courts after getting the permission from the Delhi Sultan. Delhi Darbar, he gets permission, and he has got Adalat, Fauzdari Adalat, Diwani Adalat. Diwani Adalat are the revenue courts. Fauzdari Adalat is the criminal courts. So this man establishes courts, but there is no law. In India, the problem was law courts came first without law. Nobody knew how to administer law, but there was no law at all. Each one was having his own law. Mohammedans were having their own law. Hindus were having their own law. Then caste laws were there. This law was there. Everything was there. So much of confusion. But courts came. These courts were manned by the servants of British East India Company, who were adopting the principles of British thing. Because, as I told you earlier, in England, the common law developed because of judges. I told earlier. Like that, he also must have thought that if we establish courts, common law will develop. There will be more peace in the society, so that people will be free from their troubles. We cannot doubt their intention. But what had happened was, these courts started employing certain principles which were alien to ours. For example, what happened was, for the debt of a money lender, when a money lender, not a mortgage debt, a simple hand loan of the money lender, the land of the peasant was getting expropriated. There was attachment of his land, which was unknown to Indians. In our panchayat system, it was not there. The land was not approved for money lending thing. This was very, very thing, troubled our people. So what they did was, they started resenting the courts. You must read Justice P.N. Ramaswamy. There was a great judge in Madras High Court by name Justice P.N. Ramaswamy, ICS, who rose from ranks and became an High Court judge and retired. In one of the Supreme Court judges, Justice Shah has written that the classic has given encomiums publicly in his judgment on Justice P.N. Ramaswamy's judgment. P.N. Ramaswamy, he has written a book, Police and Magisterial Guide, Magisterial and Police Guide, 2 volumes he has written. MLJ publication, I don't know where it is available in print, but it's a classic book which you must know to understand how the situation was and everything. That's it. So why I'm trying to tell you is, P.N. Ramaswamy argues that these people found the courts, the British courts, anathema. They didn't like those courts at all. They started shifting, villagers started running away from these courts. These courts were, according to them, these courts were a den of injustice. They were not patronizing these courts. However, these courts came to stay. Then what happens was, 1802 Cornwallis regulation creates Cornwallis regulation number 10 of 1802 sows a seed for the creation of vakils as a profession. We advocates, our ancestry, our thing is relatable to regulation number 10, Madras regulation number 10 of 1802, which contemplates that vakils should be created in all the courts, because to help these litigants to litigate. Vakils were created. Now, 1802 creates, in fact, for your benefit, if you go to our Madras High Court website, we have hosted the 1802 regulations. They put them in the public domain for everyone to read it, because it's a gold mine, my dear friends. It's a gold mine, a treasure, which you will find whatever, if you want to know the history of any arbitration act or anything act, go to 1802 regulation, you'll find a parallel to that. CRPC, IPC, everything will go to 1802, you will find some thing to that. So 1802 regulations creates an institution called vakils. These wakils were local people who were appointed by the Fauzdari Adalat or were appointed by the local Diwani Adalat judges to practice in that court. Now, the whole problem was these wakils, instead of this is the problem is these Britishers thought that, like the bar of England, we must have to create a bar. There, England, the bar grew along with the court. The bar grew along with the court and the common law, and the bar had a great affinity to the institution of court. Whereas here the court was, from top, a court was established. Then the court had certain rules like what I told you. Then the court creates wakils. Wakils are attached to the court. So, this wakil cannot go to other adalat and argue. These were the regulation 10 says. And what had happened was the court became a sort of a temple. Wakils became priests. As usual, they started behaving like priests. Priests, we know, priests thrive all over the world. The priests thrive on the fear in the minds of the devout all over the world. The principle for the priest to thrive is that they create the fear of God in the minds of the common man, and the priests thrive. They don't create a love in the minds of the common man for God, but they create fear in the mind. These wakils, what they did, but they created fear in the mind of the common man on this court institutions, and it was very comfortable for them because these poor, unlettered, ordinary peasants didn't know. They thought that once a summon comes from here, they started shivering coming to the court, and most of these litigations were civil litigations. The civil litigations were generated, and to add to the woes of the system, a third category of institution developed called touts. These touts, what they did was, they will be the wakil's representative, pick up cases from the village countryside, bring them over here, fix these fellows, and create havoc. Beside this, for the benefit of MBA audience, Madras Bar Association was started by barristers exclusively here in the High Court, and the first resolution of Madras Bar Association is the barristers resolved not to engage touts. First resolution was, we shall not engage touts. The second resolution by Madras Bar Association was, we shall not undercut fees. One senior advocate asking, I will do the petition for 100 rupees. Another petition, no, I'll put for 75 rupees. This sort of undercutting, let us not do. You just refer to your old books, you will find. So why, this illness from the Mofsal area came into the presidency towns also, and that illness got. Now, why I am trying to tell you is this court institution, as it stands today, was never accepted by our people. Were never accepted by our people. The court institution, the people even today, even now, they say that in my family, we have never stepped into the portals of a court. I used to wonder, what is wrong? Is court a place of sin? Is it house of sin? Is it a gambling house for you to say that I will not step into the courts? This is the attitude of the common man. Now, this institution, and it grew, and the Vakil institution added to it, Touts institution added to it, and it was very comfortable to wreak vengeance. And you get a man's property entangled in a litigation, finished. He cannot sell the property, he cannot do it. This is the problem which faced. And for that, you get into the witness box and keep speaking lies left, right, and center, because you are sure that you can speak any lies in the court of law and get away with it. Now, this is This, as I told you, on the civil side, the cascading effect was the increase in criminal cases. You conduct a study, law commissions, lot of law commissions study. It's not something new. The failure of the civil justice system, the immediate impact is increase in crime, because the frustrated litigant, the frustrated brother who loses unjustly a property in a court suit, in a court litigation, he takes to the weapon, he attacks. If he's not able, if the courts are not able to decide a border dispute, how border dispute used to be decided, in England, the jury system itself evolved only to decide civil cases first. Because when there was a dispute, property dispute, the court used to meet, the jury used to be people from that locality, and yes, this man's property border is this, that man's thing is there, they will say, and the whole case will be decided faster. Only then the jury was introduced into criminal system. So people are on the impression that juries are the criminal system. It's not the civil system. We tried to do with jury system in criminal cases. It ended in a total failure in our famous Nanavati case, after which jury was given up. It's a different issue. So when the civil system fails, when the civil court system fails, the first impact is increase in crimes. Are Indians basically, to understand, my dear friends, we are not criminally propensity people. We are not people with criminal propensities at all. We are absolutely peace-loving people. We accept whatever happens. Otherwise, you see, how can people accept a 5-star life? They see a huge 5-star hotel, then they agree, my lot is this, I have to accept this. They don't revolt against it. Even the big revolution doesn't take it, because here man accepts it. He may, the number of jails we have, the number of inmates we have is far very less when compared to the population we have in this country. There's no doubt about it. In America, 33% of Americans go to jail. This is what I was told when I was there in Alcatraz prison as a visitor. They said 33% of Americans go to jail, whereas if you take Tamil Nadu population, 0.0082% of people only go to jail. That's all. So if we are not criminally propense people, the criminal cases increase because of the failure of the civil system. Now, as I was telling you, that we use the civil court as a means to wreak vengeance, and there are two classes of litigants. P.N. Ramasamy in his book, Justice P.N. Ramasamy in his book would say, there are two classes of litigants. One is a person who cannot be induced to go to the court even as a witness. And there is a class of persons who cannot resist from going to the court. Now, even you let us take, for example, supposing a murder is going to take place in your presence. Will you ever go forward to be a panchayatdar and help the police in the inquest? Will you ever, even if a recovery is going to take place right under your eyes, you are not going to say. Whereas for the police, who will come? Only the street talkers like Prem Kumar Paniwala will come for giving evidence. So this is the commitment we have towards the court system, and the court system is a place of industry to carry home money. That's all. And beyond that, we would not like to have the system built from the grassroots. And we have a population which is, truth speaking, in their own environment, in their environment of the banyan tree, in their environment of the way they think, you put before their castemen, before their kinsmen, before their family, such an open, transparent system of judicial will definitely was working, and that is how we were running this country all along. So this new system has made perjury a part of life. Now, people like Vasudha Digambar, I don't know how many of you read about Vasudha. They were the senior advocate of Supreme Court. She died some time back. She has worked with the dacoits of Chambal area, Law, Power and Justice. She has written a book by name Law, Power and Justice, where she says that for over a period of time, we have been slaves. Various aggression, this aggression, that aggression. So our Indian psyche is in a very low esteem. No? Self-esteem is very low amongst us. And deceit is the best weapon of the weak. To fight the strong, when you don't have the enough strength to fight the strong, deceit is the best weapon. So culturally, I mean, over a period of time, say about 500 years, because of our slavery, we have still not realized our entire potentiality or self-esteem, and we use deceit as a weapon to fight the strong. This is what these people say. We'll have it that way. This is something which we have to, all of us should have to ponder about it. And we also know that respectable persons, as I told you earlier, will not come to give evidence for various reasons. The one principal reason is Section 146 of the Evidence Act. Now, what does 146 say? The character of a witness can be attacked to impeach his testimony. So this gives a long, there are our own brethren who have the great propensity to put a witness in the box and keep asking him all sorts of questions, taunting. I have also seen original side before the poor master, the nature of questions in an ordinary simple suit on a promissory note or a simple suit on goods sold and delivered. How did you come? Did you come by bus or did you come by, you could have descended from heaven or what? You must have come by bus. Did you speak to your lawyer? Yes, he has to speak to his lawyer. Then only come. And this nonsense we are all tolerating because we have no concern for the person who comes to give witness. In England, 2 trials I sat in Old Bailey in London, as well in America I sat in 2 trials. Any irrelevant question by any such taunting questions by our counsel, the jury will just note down that advocate will be debarred, because the jury will feel that tomorrow if I am going to come and stand as a witness in that thing, this man is going to harass me. We don't need such lawyers. We need lawyers who will be in a position to work for justice. That is why we are wasting. We have not gone to our work. We are coming and sitting here to judge. Whereas here in our law courts, 146 Evidence Act is a great weapon to completely demean a witness and make him look small. And an amendment had to be brought by the legislative parliament to 146 saying that rape victims cannot be subjected to such thing. Now, this is the situation. So what I'm trying to tell you is that our attitude towards court, our look at the court, and our outlook, our interaction with the court is not one of love or the great affection for the institution as a protector of justice. It is more out of fear. And this continues this law. Now, this is one explanation which I have given you. Now, I will come to untruth. I told you something about untruth. Untruth is people speaking something which they believe it to be true. They honestly believe that what they are saying is true. And they keep telling that, repeating that again and again and again. This is really possible. This is really possible. See, in the cross-examination of a witness, if he's speaking a lie, you can easily break his evidence because 20-30 minutes later, he will self-contradict himself because lie requires memory. Truth does not require memory. Simple. Truth requires no memory. Lie requires memory. So probably what will happen is, if a lying witness will forget what he said earlier in the course of his testimony, what he said, by the end of the cross-examination, he will simply crumble. This is a lie speaking test. Untruth is a person who believes something to be true and he keeps repeating it again and again. Now, a lot of research has been done by Elizabeth Loftus. Elizabeth Loftus has written a book which you should read, Eyewitness Testimony. She has conducted a great research in cases in America, where she has found that because of the wrong testimony, or not the false testimony, wrong testimony of a witness, people have undergone convictions. People are undergoing conviction. Juries have convicted them. And this happens because the human memory is not capable of behaving like a recording machine. I would also draw your attention to the judgment of the Supreme Court in 1974. 1974 Supreme Court 704. 1974 3 SEC 704. 1974 3 SEC 704, where in paragraph 13, on the witness stand, the book's name is On the Witness Stand. There, a research was conducted that some people were asked to do some work. Suddenly, amongst them, a crime scene was created. They didn't know that it was a drama of crime scene was created. And thereafter, each one of them was asked to give a narration of what they saw. Each one gave a different account of what he saw. In the Jain philosophy, they used to say that if 5 blind men are asked to touch an elephant, each will touch one part of the elephant and say, according to him, which is true. For him, that is true. If he touches the one who touched the legs of the elephant, he will say elephant is like a pillar. If the other one who had touched the tusk will say something else. If you touch the thing, it's like a wall. The body will say something like a wall. So, a study conducted shows that witnesses' perception level differs from person to person, and each one has his own way of perceiving a certain fact, common fact. Now, there are 4 fundamental things, my dear friends, when you see a particular event. First thing is the circumstances under which the event took place. Suppose you are seeing somebody hacking somebody. Circumstances is that whether dim light is there, post night area, or evening, or daylight, what was the crowd there, bus stand. That is the environment in which the occurrence takes place is one thing. The next thing is your state of mind at that time. Whether you are able to witness it, whether the moment you see somebody taking the knife, you start getting tensed, you start getting perspiring, because something, or you are looking at it in a cool manner, that depends upon person to person. It's not common to everybody. 2 things. Third thing is the time taken after you saw it and to the day on which you have to give evidence. The intervening thing will get you other information which will superimpose over your memory. Third. Fourth is, after getting to the witness box, on seeing the environment in which the court is and the advocate wearing gown and everything and cross-examining you, you will start trembling inside, and you will stop. You will start talking things which you would not have really wanted to speak. Though you are a truthful witness, though you have seen the incident, but 4 intervening things will make you to speak untruth. You are not speaking a lie. You are speaking something which you believe to be true, but which is not true. This is what in Papanasam film, which is a remake of Drishyam, Kamal Haasan, you recollect the film, simply that murder would have taken place, Kamal Haasan would have, all the 3, that is Kamal Haasan, the 2 children, and that wife. They dig the body, keep it in a place. Then Kamal Hassan decides, all right, we are going to a yoga and meditation camp. Let us go. On the way, they will tell the tea shop fellow, we are going to the yoga and meditation. Then they will tell that bus conductor, same thing. Then they tell the hotelier, same thing. When police investigate alibi, though the yoga meditation thing would have got over on the day when the offense took place, still he will go and lay the foundation with all these witnesses. All these witnesses will believe firmly that Kamal Hassan and family went for the yoga and meditation. Any amount of cross-examination, any amount of questioning by the police will make them believe. The last thing was that the child will also believe that the body is kept under the place where it was originally kept. But Kamal Hassan, that he would have removed it and reburied it in somewhere under the police station and buried some pig or something there. Because he knew that that one day or the other, if all these three people buckle and conduct a 27 recovery by bringing the police, the dead body should not be there. The child believed that the dead body was there and thing. So the thing is that you speak the truth, but because of these circumstances, your truth becomes untruth. So it is not a lie. That is why we said that FALSUS and FALSUS and omnibus will never apply to India. This principle will never apply to India because culturally, historically, practically, scientifically, either way you look at India, this business of FALSUS and FALSUS and omnibus, if it had applied anywhere, it would have ended in a disaster in this country. And that is exactly the reason why we have rejected it. Now, then the last portion of my lecture is philosophically. Now, philosophically, I would say that the present system of judicial system, which is now vogue there in the Western countries, which is now vogue here in our country, evolved from Greece. Greeks were the earliest city-state. You must have read Plato, must have read Aristotle, and all this. Socrates was there, and the Greek system came into Roman system. From Roman system, Romans conquered the Europe, and that is how the system developed. Now, the Greeks believed in linearity of time. They believed that time is linear, and justice should be rendered in your birth, before your death itself. Justice should be rendered. There is no question of life here and after. There is nothing. Socrates alone, if you see his dialogues at the faculty post his conviction and during his period in death sentence, if you read Socrates, you will find that that man was speaking about the rebirth of the soul, the imperishability of the soul, as found in chapter number 2 of Bhagavad Gita, Samkhya Yoga. To a very large extent, you will find that Socrates will be speaking about that. However, Greeks generally believed linearity of time, and the linearity of time was carried to Romans. English, all the things, they all believe this is only life. You enjoy in this life, you get justice in this life, nothing. On the contrast, Indians believe in cyclic form of life. We believe that in this life, we are fatalist. In this life, whatever injustice happens, there will be a life in which we'll get back justice. This is our firm belief. So we suffer injustice. We don't revolt against injustice. We suffer injustice because we take, all right, in the previous birth, I have done this harm to this fellow. Therefore, I have to suffer this thing. No, for a group which believes in afterlife and cyclic time, you are planting a philosophy practiced by a legal system practiced by a group which believes in linearity of time. How will it work? That is how all these things will happen, and it will not work. I'll tell you one anecdote, one final anecdote I will tell you. It happened. I don't want to name the persons in this anecdote because they are all alive. They should not be there. In my house, there was, yes, a domestic help by name X. X was married to Y. And X and Y had two children, small children. X had a sister by name A. She had two daughters. And A was estranged from her husband, and A with the two daughters were living 2 streets from X's residence. Y used to drink every day, beat his wife X, asking her for more money for drinking. And she used to come to our house, any amount of panchayat, no, nothing will stop this wife from drinking and beating his wife. Nothing could do, we could do nothing. On one day, what happened was, Y was heavily assaulted his wife X. She went 2 streets ahead to her sister's house and she was weeping. She was asking for money from sister. Then Y came to sister's house and picked up a quarrel with his wife. So the sister intervened and she was trying to protect Y, protect X. This Y fellow took a knife and stabbed the sister and killed her. Right before the eyes of X, A died. Husband was arrested, everything bailed. When trial happened, I was really surprised. X got into the witness box and stated that she did not see her husband stabbing her sister. She simply said, she turned hostile. For our mind, we ask, see, this man has been beating you so much and you turned towards hostile. How do you do that? After some 1 or 2 years later, I quietly broached this topic and asked her, why did you do like this? You saw your husband. You know what the logic she gave? She said, Anna in Tamil is brother, I have two children. My sister has left 2 children. Her husband has gone, left 2 children. 5 mouths are there. If my husband goes to jail, 5 mouths will starve. So I thought that we can, at least this fellow will work and maintain the family. And mind you, he did work, get those 2 daughters married, and lived with thing. This is a special dharma. See, this is now. Can you say that that witness? Yes, she did speak a lie in the witness box, saying that she did not see her husband stabbing her sister. Sister was very dear to her. Husband was she used to hate her husband because of the beating she suffered. But over a period of time, the entire polemics changes because she feels it a practical dharma. Practical dharma is that she 5 mouths are there, and this fellow. So these are all the things which in an Indian scenario we should have to bear in mind, and we should have to address the issues of falsity in courts and find solutions to this. Now, what is the take home? Now, my dear friends, this COVID-19 has come to stay. It is going to entirely change. There's going to be a paradigm shift in every aspect of human life. And I am sure that court system also is going to change. Lawyers' attitude towards court, everything should change. Litigants' attitude towards court, everything will change, automatic change. Judges, we have to reinvent ourselves. We judges should have to reinvent ourselves. Lawyers should have to reinvent themselves. All of us together have to reinvent themselves. Of late, there is a group of people who are there, who have brought about a book also, which says that how to handle court cases without the help of lawyers. That book is freely available in the market. And those groups are containing training classes saying that you don't have to go to lawyers. You can handle court cases. We will teach you. Now, how are you going to deal with such people? Are you going to go and beat them? How many persons you can beat them? No, you cannot. Then they have justification is, yes, court is full of lies. Court is a place where you will not get justice. So we will have to have alternative system of justice. These are all the things that is bothering me of late. Now, as I told you, we have Vadivelu Thevar's case. Vadivelu Thevar's case, year 1957 Supreme Court 614, which classifies witnesses into three categories. One category is only speaking, truth-speaking witness. Second category is partly true and partly untrue. Third category is wholly lie-speaking witness. First category, take the evidence. Second category, look out for corroboration. Third category, eschew the evidence. This is what Vadivelu Thevar's case has stood till now. Now, to make courts still more respectable and earn the goodwill of the common man, we all should have to work out and ensure that there is no iota of perjury in our court system. Unless we give meaning, otherwise there's no way by which having Mahatma Gandhi's photo alone and Thiruvalur's photo alone and saying why may William, these external frills are not going to take us anywhere unless we address these issues, hold the bull by its horns, and reinvent the entire profession and the court system. If we fail to reinvent, my dear friends, post-COVID, all of us will become irrelevant, absolutely irrelevant. And I really am not able to foresee what would happen when we all become irrelevant, because in democracy, we are a very important pillar. And if that pillar is going to become irrelevant, then the other two pillars are going to dominate the lives of people. Then there will not be a court system that developed in England to protect the common man against the tyranny of the state. No, we will not be there to protect the common man tyranny of the state. And if that is not there, finished. That's the end of democracy. So how do we reinvent this? We must have to do some lot of introspection. We should also do as judges. We are not because we have all come from there to here. How we could make the system pure, how we could make the system simple, how you could make the system serviceable to the common man. And if the respectable person does not find the court system comfortable and congenial, then we go back to Prem Kumar Paniwalas. And today Prem Kumar Paniwalas are becoming extinct. There are no thing. We are slowly evolving from a primary agricultural and feudalistic society, which we are slowly going to a middle class society. So when we grow into a middle class society, we need to reinvent and have better values and higher levels of ethics and morality to uphold the very system for the very survival of democracy in this country. So FALSUS and Omnibus, like the American system, we should straightly try to bring it into our by sheer practice and by sheer conduct, keeping in mind that the system's purity is more, the system should survive us. Thank you for this wonderful opportunity. I wish you one and all, I wish you all to take care of your health, your physical, mental, and spiritual health, as well your learning, so that post-COVID, we all make judiciary a great institution. Thank you. Jai Hind.